Well, it is 9 o'clock. This is a special meeting of the Mills County Commissioners Court on Monday, June 7th. Appreciate everybody coming in for a special meeting. This was posted publicly pursuant to the Open Meetings Act. Here in the courtroom, we have all 4 commissioners and the county judge for the first time that I can recall, at least probably a year. So we have a quorum. Also present in the courtroom are the county clerk and the county treasurer, and Jackie Brooks is moderating the technology from her office. We are expecting Jeff Ullman to join us via Zoom, and Jackie will be checking on him. We'll rearrange the agenda a little bit to accommodate his time, and I think I saw the reporter from the Gulfway Eagle a little earlier. So with that, let's stand for a quick pledge of allegiance and a prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Commissioner Williams, could you lead us in prayer?
Dear Heavenly Father, bless this day that you have given us. Thank you for this rain that you have bestowed upon our county. Be with us and guide us today as we do the business of Mills County. Direct us in all your will. In Jesus' name we pray. Amen.
Amen. Okay, let's look at, we have the minutes of our last meeting, May 24th. I missed this one, although I watched it on YouTube, which was interesting. Any comments or corrections on the minutes of May 24th?
I'm moving to approve the minutes as written.
We have a motion from Commissioner Wright. Is there a second?
I'll second it.
Second, Commissioner Guerin. All in favor say aye.
Aye.
Any opposed? Minutes are approved. I see Jeff Ullman has joined us from the Knight Law Firm in Austin. Welcome, Mr. Ullman. Can you hear us?
Yes, sir, I can. And thank you. Good morning.
Well, let's see. Jeff, we're having trouble hearing you. If you're hearing us, would you give us some sort of hand signal? Okay, so you're hearing us.
Yes, sir.
Check. Let's see. Make sure you're not muted. You don't show muted on this end. Can you speak?
Yes, sir. Are y'all able to hear me, sir?
There you go. We heard that muffled. If you could either speak up or increase your volume. I think our volumes are set on max on this end.
Yes, sir. I will do my best here.
No, not getting anything.
Is that better, sir? Okay, I'm trying to boost my volume. Are y'all able to hear?
Yeah.
Yeah, that came through.
Okay. I may have my face right up in the screen. I'm trying to get as close as I can to the mic.
I appreciate that. That seems to help a lot.
Okay.
We're going to skip over accounts payable. We have no individuals that have signed up to speak, and go directly to the items that we have asked you to participate with. For the record, we retained Mr. Ullman some months ago for assistance in drafting an ordinance. It was a combination of our old ordinance, our our county attorney's work and some of my work along the way. We've had new ordinances we've seen from other counties. A little bit of that is in there. But the biggest part of what Mr. Ullman's done for us is guidance on the process. And the process is that the court needs to make, it seems a little, the order's odd, but it's the way it is. We make a takings assessment to find that whether or not our ordinance has taken property. So it's taken in the condemnation sense or taken value. And Mr. Ullman can talk to some of the steps we go through in doing that. Now, obviously, we need to be looking at the ordinance as we're making that decision. Doesn't mean the ordinance can't change after we make this decision, as long as it doesn't get materially tighter. Then we have to post notice in the local newspaper of a public hearing on the ordinance. That has to be at least 30 days after we advertise. So let's just hypothetically say we pass something today on the taking. We get something in the Eagle for Wednesday, which would be about June 10th. That would mean middle of July before we would have that public hearing. The court cannot vote on a subdivision ordinance until after that hearing. We would have that hearing. We would take into consideration input from that hearing and other changes the court might want to make, and then be in a position to make the final ordinance at any time after that. It could be at that meeting, it could be at a called meeting, could be at the next meeting. But we can't take any action other than discuss until we have that public hearing.
So it's a general, it's not a regular, it can be a call meeting to take that action.
Boy, that's my recollection.
I just knew sometimes the wording is.
Right. No, we can actually vote on it immediately after the public hearing, which doesn't have to be a regular meeting. Anyway, that is my preamble. I think there's two ways to approach it. Now, I'd like to turn it over to our attorney, is some more background or explanation on this taking concept, because this is something I believe relatively new. And then obviously, as we consider whether or not there's a taking, we need to talk a little bit about the proposed ordinance. So, Jeff, what did I miss or misstate, or where would you like to go?
Oh, thank you, Judge. Are y'all able to hear me okay this morning?
Yes.
Okay. Your preamble was pretty spot on. That is all correct. The Commissioners Court could adopt the ordinance at a regular or special. Just got to make sure there's that 30-day notice like you stated. And it does, the way the statute is drafted regarding the takings impact assessment or analysis that we're required to do it, it does kind of put the court into a kind of a chicken and egg situation, because it requires us to do the assessment prior to having the public hearing. So, we, as you mentioned, based on public comments and feedback, there may be some tweaking of the ordinance, and we may have some additional things we want to tweak with the ordinance, but we're required first to make the, to approve this assessment that has been done on the ordinance. But the way the statute is drafted, you have to do that prior to the adoption of the ordinance. So it does kind of present a chicken and egg situation, but that's how it's drafted. And so that's how we're going to work with it.
In everybody's package, they have a copy of the takings impact assessment, which you drafted for us. And if you guys flip through it, you'll see the questions that sort of start on page 2. And those are the decisions for the court to make. But basically, if Mr. Ullman's read the draft ordinance, what we're doing is taking action that's prescribed by state law to protect the health, safety, and welfare of the county under various state statutes. And we're determining that we are not physically taking property. We're not physically even going onto people's property. But then it comes down to the fact of does it restrict property rights partially or temporarily? Then there's a list of exemptions. There's a test back in here that the effect is or is not greater than 25% of value of the property. And then finally a conclusion as to whether or not taking has would have occurred as defined under the ordinance.
Yes, that's a good analysis, Judge.
I'm sorry,
And-
Jeff, did I jump in there on where you were going next?
No, that's totally fine, sir. Yeah, that was just going to give a quick analysis of the takings impact assessment. But that's it. What you just stated. As the court is aware, we are authorized under Chapter 232 of the Local Government Code to implement subdivision regulations, but we're also required to do this takings impact assessment under the 2007 chapter in the Government Code. And so one of the exceptions to the takings would be that these actions are taken in response to a real and substantial threat to public health and safety, and that the ordinance is drafted and our actions are designed to advance these health and safety purposes. And we're not putting the Commissioner's Court's not putting any type of greater burden than is necessary to achieve our goals of health and safety. And as you've stated, with the booming growth and the amount of subdivisions that are occurring in Mills County, these actions we're finding these actions are going to be necessary to protect the public health and safety, groundwater. So there's also an exception there that talks about for the protection of on-site sewer facilities. So for all these things are going to be necessary for proper and responsible development in Mills County. And so those are going to be exceptions to these takings. That's why I've put together the impact assessment that states that it's not that basically this is not going to be our actions aren't going to be applicable, aren't going to be takings.
The way I looked at this, at least on value effect on individuals, was that this isn't from zero to our proposed ordinance. It's changing from where the value they have under the existing 1985 ordinance to the new ordinance. Is that the correct way to look at it?
Judge, could you pose that question one more time? I was having trouble hearing that one.
Okay. As I've been thinking through how we measure the relative impact on people's property value, my thought process was you don't look at no rules to how it changes to these rules. Instead, the baseline is the status is where we are now, which is the 1985 ordinance, which predates this taking assessment law, and the changes from that ordinance to the proposed ordinance. And does that diminish property value by more or less than 25%? Is that a good or a flawed analysis?
Well, as you mentioned, Judge, the 1985 current regulations, those were put in place 10 years prior to the requirement of this takings impact assessment. So I would imagine, I don't believe any type of takings impact assessment was done in 1985 because it wasn't required by statute. We are basically adopting new regulations. And so I think how you've stated that you're comparing the valuation from the 1985 to the current, I think that's a logical argument that could be made. I would caution slightly that because we're adopting new regulations, it could a landowner could claim that the monetary value is based upon the new regulations and wouldn't then 1985 wouldn't apply. That argument could be made because they would be basing on the new regulations. But
But the damages, if that's the right word, would be the diminishment of the property value from before we pass this to after we pass it.
Yes,
And
that's
before
correct.
we pass this, they can only do what's provided under the 85 regulations.
That is correct, Your Honor. That is correct.
So actually, what are we changing on the new regulations versus 1985?
Okay, that's a good question. Commissioner Wright's asked. It's the changes largely have to do with determining and showing on the plat that every lot has a likelihood of water. Have some sort of hydrologist study that says there's likely water, potable water available. It said every lot has a site that would be suitable to some sort of septic system. That if there are areas that are not suitable to septic use, that would be designated on a plat. It talks about in a lot more detail about direct protection of floodways, specifically the flood control dams we have in Mills County. Those have an inundation zone both upstream and downstream. And the court has seen some of the consequences of that as the state has moved some of our old dams from low risk to high risk because of development that is occurring within those inundation zones. So those inundation zones would be be required to be shown on a plat, and there would be no residential development, residential structures in an inundation zone below the inundation level. So a lot like a lake project, you can still build a house in the inundation zone above or below that dam, but wherever the spillway level is coming down, you need to have your living quarters above that. So that's a type of change. There's some traffic safety changes like spacing between driveway entrances on county roads, requirements for tin horns anytime there's a drainage crossing, requirements that the drainage be directed into the nearest waterway. There's some fire protection. There's a garbage collection provision that there be space in a subdivision for a garbage pickup point. There's provision that it's all in the category I would just call common sense. That there has to be utilities either available or utility easements platted to the edge of each lot so that anybody that buys a lot knows they can get utilities.
Well, what I've seen, a couple of issues here, what I've read on the new ones, I know there's a restriction for agricultural use under 50 acres. Is that correct?
It's requirement for deed restrictions against agricultural use. And then it requires, I believe, cross fencing and a water source.
And also, like I said, you mentioned the water source. It says it will be a storage tank that capacity at least 2,500 gallons coming into this subdivision.
That any subdivision that has to have a water storage capacity for our fire departments. 2,500 gallons was arbitrary. I've seen in other counties. There's provision in there that the court can make it more for large subdivisions. And there's provisions for small subdivisions that it can be a surface impoundment like a stock tank or a storage tank. So, I mean, collectively, the concept I've been working on is that if somebody buys a platted lot, they ought to be able to assume it's usable, has water, has a place to deal with garbage, has be approved for a septic system, have utility easements to it, and some minimal fire protection.
How about the hunting rights on 10 acres? How does that?
What's proposed in here is that there be, I think the terminology is discharge of rifled firearms other than in self-defense is prohibited under 10 acres. So if somebody wants to hunt, archery, black powder under 10 acres, there's no problem. But if we get hundreds of 10-acre tracts on opening day of deer season, it's just a public safety issue for rifles. No, shotguns, there you go. But anyway, this is kind of best efforts out of lots of input from other documents. The one I'd like to point to is something lifted from the Lampasas document. Our current ordinance says that if you violate the don't comply with, if you have an illegal subdivision, it's a Class B misdemeanor. What picked up from Lampasas, and that ultimately came from Williamson County, goes back through the penal code, that anybody that assists in that process is charged with a misdemeanor. So that gets down to brokers, surveyors, title companies, whatever. It gets away from a developer's ability to hide behind a corporate veil and say, you can't put a corporation in jail. So now it's the individuals that do this have the same consequences that our old ordinance applied to the developer. It just defines developer differently. I mean, on a value front, the way I looked at this was that, to me, the big expenses we're requiring are the hydrology study in a subdivision to know there's likely groundwater, and they're doing a septic perk test to know that there is a place for each septic system.
Under the acreage, does that not call for an elevation survey or two? If you're gonna do the restrictions on some of this water?
Well, it would, you could use a topographical map that's readily available. I mean, we have preliminary applications in now for one or two subdivisions already, and those have all come in with topographical maps of drainage wells. So it's apparently available without going out and surveying the contour lines.
Well, like I'm saying, a lot of places require that elevation survey just because of the flood
Yeah.
issue. And I've wondered can we cover everything? I guess that's my concern.
Well, the answer is no. I mean, no matter how thoughtful we are, somebody will find something
A
we
loophole,
missed.
correct.
So all we could do is the best we can do, and maybe revise it more frequently than every, what has it been, 35, 40 years.
That's correct.
Have Mr. Owens Farm firm, have they been through this subdivision ordinance? The draft that we have?
Let me ask Jeff to speak to that. I do not, my initial focus was trying to get the timelines identified, and then the long lead items, which was the takings assessment and the newspaper, the notice. But go ahead, Jeff.
Yes, sir. I believe the question was, had we drafted that ordinance? Is that was the question?
The question was, if you looked at it.
Yes, sir. Yes, sir. I've definitely looked at the ordinance, and there may be some changes coming to the ordinance still, some additional input and from any public comments or from any of the commissioners, and we may have additional items for the commissioners to consider at a later date. This is a pretty good, solid draft of what we're working with.
Does that answer your question, Mr. Parker?
Yeah, I guess.
So we're basically working on the takings orders today. Is what we need to get our ball rolling. Is that correct?
Yeah, I mean, I think there are two things. The action, the only action that's on the agenda for the court is if the court chooses to make it, is to make a finding on the takings. We also we should discuss both in that decision and in general, the draft ordinance and get raising issues to Commissioner Wright's point, things that we hadn't thought of to try and get, we have, 30 days after we have the notice to have the hearing, we can be making changes as long as we don't do something substantive. I mean, if we say minimum subdivision is 100 acres, that might change the takings assessment, but changing the driveway spacing, the size of the tin horns, acreage on agriculture, the types of flood elevations, I don't see that those would be a material change in takings.
But the takings deal is just change in value of the property.
My take on it, and we'll defer to council, was that if we determine that we're doing these things under code and for health and safety and public reasons, then the only issue that comes up is has this diminished value by more than 25%.
Yes, Judge.
Then it's not a taking. Now, my math driving in, thinking this through was, let's say, typically on the plats we're seeing lately, 10 acres. Let's say $5,000 an acre is the value. That's more than what our tax assessor says right now, but it's way less than what the developers are getting for the lot. But it's probably a low middle type number. So 5,000 an acre, 10 acres, that's 50,000 per lot. What we're adding is requiring the hydrology test for the subdivision to say that there is or isn't water and have that printed on the plat, and a perk test. So do those two things together cost more, or likely to cost more than 25% of $50,000, which would be 12,500, and I'd tell you the answer to that's no. So that was my take on it. Mr. Allman, how would you look at this?
Yes, sir. The 25% is one of the thresholds in the statute that defines the takings. There's also other in 2007 chapter of the government code that talks about the takings. And I would also contend that what we're doing under the we're putting together these ordinances and regulations for the protection of the public health and safety, and that alone in itself is an exception to the takings provision. So there's several different findings to conclude whether or not there's been a takings. And so with this takings impact assessment, we're trying to check off all the different areas of the statute that say that this would be a takings or not a takings, and that 25% is just one of the areas that could be defined as a takings. There's also the public health and safety threat as well. And so we're just putting several different things in this takings impact assessment that we believe that would show it's not a takings. So it's a multi-layered approach.
There are a couple other points I'd like to make. One is from reading some guidance from the State Attorney General's office. One of his factors in taking was whether or not it affected one property differently than another. And I would say that if we have a countywide ordinance, then it affects every property. So that issue is off the table. And well, there's another thing and I lost it. Oh, it's in the ordinance. There's a provision for a landowner or developer to come to the court and ask for a waiver based on specific circumstances. And every property is different. There could be a circumstance that we would justify something else. So although you have an ordinance, there's a provision for variances. And so that, I think, is a protection against an unforeseen taking.
You talk about taxation on it and on different prices on property. It would have effect on the 50 acres versus what we have now. We have some people out in the country that get an exemption on 10 acres on ag exemption. That does change that price on that piece of property.
Well, it doesn't affect people that do not come in and apply to subdivide. So if they just stay out there with their 10 acres, there's no change. And the other thing is this doesn't affect, we're not telling, and I'm not sure we can tell the appraisal district how to apply the exemptions. What it does say is that if a guy is proposing a plat, one of the requirements in his property owner's deed restriction is a prohibition against agricultural use. So it doesn't affect anybody that's already there. And from reading the codes on usage, it's the primary use as opposed to incidental use. So like if, I don't know how much property you have, let's say you have 10 acres and your daughter's got a horse on it. That's not the primary use of the property. That's an incidental use.
Right.
What about a wildlife?
I mean, to me, that's gonna be the state establishes the wildlife code.
Yeah.
So it's going to be a different issue of convincing the appraisal district to periodically review compliance with the requirements in the state code for the wildlife exemption. I mean,
Anybody holds a restrictions on agriculture, they can file for wildlife exemption.
Yes.
They already
Yeah.
have,
Yeah.
they already have wildlife, I mean, livestock first.
Yes.
right. Yeah.
But it has to be-
So we restrict that with the new subdivision on 10 acres. That has a restriction in it.
I don't think there's anything in there on the wildlife.
Correct.
Yeah. But to get a wildlife exemption,
Has to be-
I think you have to show what, 5 or 7 out of 11 things you're doing and sign an affidavit. Well, right now you do that, you sign the affidavit, you're done. The goal, my personal goal would be to have the appraisal district randomly in their reappraisal process check to see, okay, Mike signed, he was doing A, B, C, D, E. Does it look like it's happening?
Make sure he's good.
Yeah.
Correct.
But that's not part of the ordinance.
Nobody checks it.
No,
Yeah, that's,
it hadn't in years, have it? That I know of.
any other comments, questions?
The only thing I have from Mr. Roman, is if we do have, these subdivisions working and we have not, do not have the draft, we're bound to the 1985 ordinance agreements on these if they come in and do the plat and stuff, right?
Yes, sir, that's correct. Until the Commissioners Court officially adopts the new regulations, the 1985 regulations would be applicable.
Okay.
What would be the trigger date? I mean, obviously, one part of it is what we adopt, but let's say they are somewhere in the subdivision process. Obviously, we've approved their plat, they're done. Does a preliminary plat grandfather them?
Yeah, so if a property owner or developer came to the county and started any type of permitting process, then they would fall before the adoption of the newer regulations, the prior 1985 would apply.
Let me throw a couple of hypotheticals at you. Let's say they file a preliminary plat and we reject it because it's incomplete. Okay.
As long as it's not approved by this court, I mean, that's.
Well, I
That's
mean,
the-
Yeah, but if you stonewall somebody.
Yeah.
That's not fair.
you can't really stonewall very long because the law says if they file it and you take no action in 15 days or file it, so many days before scheduled commissioners court meeting, and we take no action in 15 days, it's deemed approved. So we can't stonewall it. If it's filed, we have to either put it on the agenda or reject it for being incomplete. And I've done that recently on.
So the court, did you review that and see if it's incomplete and you reject it, or does it come before this court?
No, the judge rejects it. I mean, the court gets it when it's complete. Now, there's the current ordinance, the new one we haven't done that way, but the current ordinance actually has a checklist for what constitutes a complete preliminary application and what constitutes a complete permanent application. So it's pretty easy just to go down that checklist and actually have a meeting this afternoon with the Indian Springs guys, which we've rejected, and they agree that they missed several items on the checklist. We're going to sit down and go through it as to what's missing and what they're going to do to get it fixed. And when it all comes together, then it comes to the court.
Should we include that?
I think once there wasn't any point in building a checklist till it got a little firmer, but I think by the time it gets to final, this too should have a checklist. You do these things to get the preliminary and these things to get the permanent. Jackie, were you able to get Mr. Ullman back live? He froze up on us.
We have him. Did he freeze again?
No, I think.
He's back
Judge,
on.
can y'all hear me?
Did you hear us in that discussion, Jeff?
I did not. I was kicked out of the. It shut off on me, so I re-signed back in, but I was not able to hear the discussion.
The discussion was centered around applications or subdivisions that are in various stages of progress as we adopt a new ordinance. You stated that if they had an application before the county under the old ordinance, then that application had to be considered under the old ordinance. That's correct paraphrase?
Yes, sir. That's correct.
There you go.
Yes, sir. That's correct.
That's Chris.
Okay. Then another scenario we have recently is we had an application that was rejected for being incomplete. So, they'll probably try and get it complete and come back way before this is done. But just as a hypothetical, if it's rejected for being incomplete, does that reset the clock on when that?
Yes, sir. I'm not sure if I'm frozen again.
No, we heard.
Okay.
You.
Okay, great. Yes, sir. If an application was rejected for being incomplete, then they would have to start the process over. And whenever they refiled, whatever was officially on the books at that time is what would apply.
Okay, one last question from me on that issue is we have several what I call illegal subdivisions in the county where they have subdivided but never applied. According to the county attorney, the statute of limitations has not run. So now the fact that they're physically have sold lots and done things without filing a plat, they would fall under a new ordinance potentially.
Potentially they could, and you would need to work with the county attorney, but I believe the 1985 ordinance had some ability to pursue them as well, I believe.
Right, yeah, they were illegal under the old ordinance, or not doing anything to get legal at this point, to my knowledge. And so if we have the new ordinance in place before they take any action with us, then they have to get legal, they have to do it under the new ordinance.
Correct. And yeah, you could, once the new regulations are adopted, you could pursue those folks under whatever is currently enforced with the county. You'd want to work with the county attorney to look and see, they're all going to be on a case by case basis as far as, are you able to enforce efficiently with your old regulations, and that could be pursued, currently, or you can, once the new regulations adopted, you could pursue them based upon the new regulations.
Commissioner Parkin, this is really your question and we hijacked. Does that cover your question?
Yeah, I just, the time frame with the takings deal, then the 30 days, you depending on the court, you could be looking at fall before a new subdivision ordinance. So my biggest deal going forward with these that are basically happening right now is where we stand, which is with the 1985 agreement until we get something else in place.
I think you hit it. I mean, which is why basically I've called for a special meeting. I mean, there's all these long lead times and we never get to the end until we get started. And so that's what we're trying to do here. And I realize that already a couple in the pipeline.
I didn't realize that the one down on C-Bar was already under construction. I was by there this
Yeah, they got
weekend.
bulldozers and everything up
I
there.
think what they're doing is, what I've been told, they're pushing their right of way to build a fence. So I can't go on their property and check it anyway.
To build a fence.
That's what I was told. They're building a fence around the perimeter of the property. And also, that could be water line. I don't know, they're supposed to upgrade that water line. They told the judge and I from a 2-inch to a 6-inch. Is that not correct, Judge?
That's correct.
That's what I've been told. So I can't dispute what they're doing. I mean, I don't have a right to be on the property.
So the one out in my precinct, on the old Chad Henderson place, he's already out on mine, is he's already started clearing right of ways and different things like that. And he told me it was just for fences, and then and that's all he told me. And then 2 weeks later, he called me and said, I'm going to divide it into a subdivision. So,
Well, like I'm saying is that we met, that's the reason I had this developer meet with the judge and I both. And what we discussed was all on up and up, but he's built new fences on all his places that he's bought, just not on the subdivision. And yes, I've seen on one side of the road that same deal out here, but I can't go in there and tell them that what they're doing on their property. That's you're defining something that I don't think we have authority to do on the landowners telling you what you can and can't do on your own place.
I might just point out for the court's information that the existing ordinance says they're not supposed to build any roads until they get the approval from the court.
Well, I don't know if they're building roads over there.
I wasn't saying they were. I'm just saying.
I was told they were building a perimeter fence. They're pushing right, and we pushed right away for them already on county roads. But that's for fences. That's all I know. And that's all I've been informed, and that's fine. Do that.
It'll all come out in the long run.
Yes, yes.
While we're blessed with Mr. Ullman's counsel, do we have more questions on the legal side of what we have to do before we can get to the
Well, I
The
just know
posting.
that Dale's concern, and I knew that was a big concern for all of us, is that what we have to abide by and go by is our 85 ordinance. You know,
Yeah.
until we get this, the court approves it, you know.
Well, I mean, there's lots of questions that, even the subdivision are asking or saying they're gonna be, which who knows? I mean, I think we're all smart enough to know their ideal is to sell the land and get out. It has nothing to do with an HOA or making sure that everything is done right. That's not their job, they think. But I guess my biggest concern, I don't know about this one or the one out on Anderson. The one over there by us is supposed to be a gated community.
Have y'all sat down and met with the developer? Because that's the first thing I did in my situation. I got them involved with the judge.
And he told me he wasn't gonna do a plat.
And with regard to Indian Springs, Dale and I are meeting with two of them this afternoon.
Because I think that's important to start with.
We
is
got
that
caught.
we have to do it go by the right way doing it. I mean, that's.
We got caught with the COVID deal. We've met with the guys several times, Zoom or on the phone. Have not met with them in person yet. But I have huge concerns out in the country with a gated community on a subdivision that somebody buys a big parcel of land. I think they realize if they got a special entrance, if you have a fire or you have need for an ambulance, you may kind of be on your own. When you take a group of people like that, if your neighbor shoots you, how's Mr. Hammond supposed to get in?
It's gonna be hard on the gate.
Cut the lock.
Ours is mine out my way.
They
It's
do.
stuck in the gate.
That's what the fire department does, do they not? Cut fences and locks, whatever, they have to have access.
Yeah, I mean,
That's,
I guess my big question would be, who's gonna be enforcing the ordinance?
Yeah,
Mhm.
definitely.
Innovative.
well, what we were told, the judge and I, on this situation, on this gated community, on this 310-acre tracts.
28 is 310 lots,
Yes.
2,800 acres.
Yes. But what the deal of it was is that we were reassured that there would be a gate beside the gate where you would have a combination to get in. If you couldn't, you were more than welcome to cut the lock on the gate beside the automatic gate. Was that your understanding, Jed?
Yes.
It's my understanding too.
We're covered, you know, if it's necessary to start, we're covered in whatever we have covered.
Where that was medical or whether it's
Yeah.
fire department, or whether it's law.
Yeah, in the land passes ordinance, and I think I borrowed some of that language. They require either the codes or what they call a crash gate,
Yeah,
which
that's-
I
that's
think is
what we
like a
were-
bump gate.
That's what we were told was gonna happen on this
Okay,
subdivision.
we're running Jeff's clock here, so let's try and, while we're solving our own stuff. So let's try and think, I'll make the motion. I'd like coaching from Mr. Ullman, if I've said this correctly, that I would say that after consideration of the outline points of the taking impact assessment, that the court finds the proposed ordinance is not a taking as defined and authorizes the county judge to execute the assessment.
This is just a discussion, though, is it not, Judge?
Well, it so far it has been, but it's listed for potential action on the takings assessment, not on the ordinance. But we need to get the assessment done, or an assessment done, before we can post to have a public hearing on the ordinance. And that's which you have to do before you can approve anything. So I'm trying to get us through step one.
I'll second.
There's a motion and a second. Mr. Ullman, would you recommend any amendments to that motion?
No, sir. The motion as stated is sufficient.
Okay. So we have a motion and a second. All in favor, say aye. Aye. Any opposed? Okay, that's important. The assessment has to say how many ayes and nays. Okay, so that's our action item. We also had listed under item 5, just discussion of the ordinance, which kind of flipped back and forth. What I would propose at this point, since everybody's got it, why don't you just mark it up? Maybe send them through Jackie so we get everybody's comments on them, and we'll put it on the agenda again. Then I'll recreate a red line version with everybody's input and have it on the agenda for a regular meeting Monday for further discussion. And we'll just keep discussing this. Meanwhile, with the assessment done, we will try and make the deadline today for the Eagle to post for a public hearing 30 days after Wednesday, or the closest date we can come up with. And we have the intervening month then to hash out among ourselves what we fine tune this, have the public hearing, and then anytime after that we can vote. Okay, thank you, Jeff. I will keep you in the loop as we circulate red lines with changes.
Yes, sir. Thank you.
Okay, let's get back on the agenda. We have accounts payable that were circulated Friday electronically, and I think by hard copy. Anybody have any questions on the accounts payable? Yes, Mr. Ullman, you're welcome to stay, but I think we're done with things that would require your counsel.
Okay. Thank you, sir. Thank you for having me this morning.
You are excused. Okay, we're talking about accounts payable. We've got okay, let me see what happened to her. I thought she was present.
She was, but they got payroll today. So she'll be back downstairs.
Okay. Ms. Campbell is showing muted. Ms. Brooks, if you're controlling the mute button, if you would unmute Summer. Or call her and ask her to unmute herself.
I'm available.
Okay, we are just now starting on the accounts payable, Ms. Campbell, and I was calling for questions by the court. Any?
On precinct 1, if you'll look at what I bought a battery, and that battery went on that generator where they could start it out here. I'm asking for that to be refunded to my account.
So you want to put it on general, it just needs to go to.
Everybody has a share of it, just
Yeah.
not precinct 1. I don't think that's right. You know, me buying the battery and then us selling it, and
Just needs
it
to go
was
to
$91 and
So I guess that means you don't want the proceeds from the sale of the generator.
we don't get them anyway. It goes into road and bridge
Yeah.
anyway. It just splits out.
Well,
the 4 of us.
Ms. Campbell, where do you think we should put that?
Well, we can either split it 4 ways between the precincts, or we can divide it up into like a miscellaneous expense. I would just have to take a look on that.
Yeah, we'll just put it in some sort of county overhead category.
Okay.
Can we put it road and bridge?
Well, we could do that, but I was just trying to get it out. I mean, really, it came out
It's
of
really
the
more
old
general
jail.
fund.
Yeah.
Whatever y'all want to
So,
do. It's-
yeah.
But that's what that $91 is
Okay.
for the battery for that generator. They wanted to listen to it run. We've started it before, and now
You taking it out there?
We did it this morning.
Okay, yeah, we'll just put it in a county general, or building maintenance or something like
Okay.
that. Okay, anything else on payables?
But yes, I will take the, whatever it sells for. Since you said that, Judge. I have no other questions. I make a motion to approve the accounts payable.
I second them.
Okay, we have a motion and a second for approving, to approve the accounts payable. All in favor, say aye. Aye. Okay, we are done with that. Let's see what else we've got. Commissioners' requests and reports. Let's start with Commissioner Ryan.
We've been doing some road work. Of course, it's been raining so much. We want to blade, but it's hard to blade. So we've just been doing filling potholes and stuff by hand. You asked about the generator. I talked with Cowboy last week at the auction, and I told him what the court approved was they wanted at least $10,000 for that generator, but didn't PO it. And he said he would, but I took it to him this morning at 8:30. That's when he wanted it. And he wanted to have it out there all week. So, and also, I'm gonna be out starting Friday, Monday, Tuesday, and Wednesday. I have some health procedures they're gonna do on me, so I'll be out. And that's all I have to do.
Thank you. Commissioner Guerin.
We've been grading roads, cut brush, watching it rain. Engine project, pretty wind farm going full bore. So you'll go out there and watch the excitement. It's there 24/7.
Has the vertical construction started?
They brought the towers in today,
Okay.
or started last week. They hadn't started setting them up yet, but they're still pouring concrete and all the foundation.
I keep that going 24/7 too. Don't
It takes 700 yards to pour a foundation for one.
Lots of.
That's a lot of concrete.
Is that it? Commissioner Williams?
Precinct 4, we've, kind of like Mike said, a lot of rain, pretty muddy out there. We have been on 430 trimming brush on days that we could get out there and not get stuck, or we've hauled some material on a few places where we got bad beat out and potholes, and trying to fill those up on mainly 417. Other than that, worked on some equipment and stuff. So that's it. Oh, I guess I need to mention, we did have a company come out, Axis Cameras out of Austin. And those Axis cameras, they put up a test camera up on the swinging bridge, and it was really clear. I got a picture if y'all want to see that they sent me. I think I sent it to the judge so he could see. They only went up to right below the bottom first beam, cross beam there. And we're going to actually put it on the second one, but they're working on figures and stuff for us. San Saba was over there, and I think the judge said that San Saba Commissioner's Court has talked about it several times, but we're going to do this as a joint operation between the two of us. Depending on how much the county wants to go in the process, you can make it that Clint can hit a button and look at the camera and watch it all day long if he wanted to, or if he didn't, or you can make it available to the whole public.
Is it web streamed or is it hardwired?
No. Well, it's gonna be hardwired. It's not gonna be Wi-Fi.
Okay.
And the co-op has been awesome about, they're gonna help us do all the setup and move everything over there. I don't understand all the technology, but there'll be fiber cable that goes underneath the bridge, but it ties into, they'll have something that joins the fiber to the Cat5 cable. So, a connector. So there's only Cat5 down there, Cat6.
It's all the repairs been completed.
All the fire, yeah, and we're getting right now, there's probably at least 100. Well, the Memorial Day weekend, there was over 100 cars on Saturday that was in the camera. So that's getting a lot of use in the last few days.
Lots of
But-
business.
Yeah, but the roads, they sure have made a mess of the roads too, so. And which way you want to go. But anyway, it was really nice to see the camera system. All the landowners out there love it. The landowner across San Saba County, he's willing to help pitch in. If we wanted to make it a live broadcast, we could, but we'd have to have, it's gonna cost so much every month. But this camera company is saying you could get people to sponsor it and pay for it. Maybe the Chamber of Commerce and the two communities to pay for it. And it would help the two communities. But
How much
right now it's $5,100.
a month?
No, $5,100 to put the cameras. in.
Right, but I'm talking about.
I don't know.
To host a
I don't know
live
what the
video.
host would be. I do not know that, but right now, but we're adding a third camera because you can't see San Saba's side and we don't know what that, you can't see where they park over there. If y'all all been out there, you know.
Where is the dividing point on that bridge? Where is the dividing?
Right in the middle of the river.
Is that-
So we get 2/3 and they get a third. San Saba gets a third. But San Saba is gonna cover that extra camera that they're gonna put up. So the way the cameras work, they go up on both those towers and they shoot back and they catch each other on the side. It's just that parking lot over there where all the mischief is. They seem like they park on San Saba's side. And
Reckon that stop the party?
no, but maybe it'll
Be good video.
good video, good entertainment.
Mr. Parton?
I guess I'll just start by saying we did have wind turbine people post our roads that there was supposed to be no heavy haul traffic, which were really not getting stopped. Ours, some of the locals, but Jed talked to one of the truck drivers one day. They're not even giving county roads, they're giving GPS destinations. So they just kind of find their own way to where they're going. And we did have them put signs up. Of course, they put them on highline posts, they put them on fence posts. All the way over to Indian Gap, the signs lasted 2 days. They're all gone but one. That's on the lighter note. Work-wise, we've been hammered with rain and pretty. East of Brady right now is up to 14 inches since the third week in April. We're working on washout bridges. We got a lot of washout. Friday before last, we had 4 inches in less than an hour. It washed everything out east of Brady. So we're patching.
Well, speaking of weather, I think the judge's report is largely going to be on the hail damage to the courthouse. We shook out the adjuster's report out of TAC. It had sat for too long. Got copies of it. TAC is hiring an engineer to do a second assessment of the cost. We have been given the go-ahead to replace the windows and said they'll pay for it, but there's a couple of surprising statements. They're not clear they're going to go along with the roof replacement. They may want the engineer, if the engineer tells them it'll be a patch, then the payments may be based on that. I don't know the schedule on this engineer coming. I gave a copy of the report to guys looking at it. Clark's got it. They're saying Clark was indifferent over patching versus repairing, which was not what we heard when they pitched the problem to us. So there's a lot of things that don't quite add up. And the report, the delay of the report indicates it might have just got thrown together quickly when we started beating on the table and not be 100% accurate. It's got the wrong county name in
Yeah, it's got Cass County
Yeah,
or something like
yeah.
that.
So that's where we are on that.
It's Cass County, but it's got a Lampasas address.
Yes. Well, what they did is it's Cass is probably typo for the end of Lampasas where they tried to chop it out of the report. And anyway, so it just throws questions on.
And we were never mentioned, I don't think any of us were ever mentioned about a patch job.
No.
I mean, that was never, ever, even from the adjuster that come out. So.
So now the engineer, Clark, I mean, we're back to that process, but at least moving ahead on the windows. Okay.
Have they been leaking? I'm sure they
Yes,
have.
they have. I mean, it's not bad leaks, but the tape is not permanent. I mean, it comes loose and the rain's coming in under the windows and it's taking a cleanup after each time and retaping. Now, after today, it looks like we're in for a couple of days of no rain, which may be good for Dale. Okay, that's all I've got. We have our regular meeting next Monday with the regular reports. If y'all would get back to Jackie, any thoughts? We'll on the ordinance, we'll do a combined red line showing everybody's comments, and that'll be a regular part of every agenda from now on. It's going to be a discussion of that.
I'll make a motion that we adjourn.
We have a motion to adjourn.
I'll
Is there a
second.
second. A second. All in favor, say aye.
Aye.